Welcome to our workshop today on leasing a premises. Before we commence, I would like to acknowledge the Tasmanian Aboriginal people as the traditional owners of this land and pay my respects to elders past and present. My name is Bronwyn Kidd. I'm the Program Manager of Business Tasmania, and I'm joined today by Mikala from the TCCI and James from Interlink. I'm going to give you a short overview of the Business Tasmania service before we dive into our topic today on leasing a premises. So Business Tasmania helps Tasmanian business owners start, run and grow their businesses. We are a statewide service, so anyone operating or intending to operate a business in Tasmania can access the wonderful services we have. One of the great things about Business Tasmania is our helpline. So you can call us anytime from Monday to Friday, 9 till 5, with any business-related question. And then it's our job to connect you to the most suitable services that are available to you. So you can ask us any business-related question. It may be questions on something specific about running your business, something to do with marketing, perhaps you're starting a business, perhaps you're looking for some advice or some tailored support for your business. Or you can also just call us to find out what support is available. Perhaps you're not sure what your problem is, you can call us and we'll connect you with the right services. So we run a series of events and workshops throughout the year. We have an event calendar where you can search for events in your area or for your industry. That's on our website. I'll show you the link for that shortly. And then we are connected to a lot of advice services that are available to you for free or at a very low cost. And we have a lot of connections with government-funded services that are available to you across a whole range of support types. We have quite a comprehensive new website, which we're really proud of, that has a whole host of information and resources available to you to help with various stages and areas of your business. So we have tools like a tool and support finder where you can find lots of resources to help you along your way. And then we also have a grant and funding finder too online, which you can search for grants in your industry or for your size of business or stage of business as well. Then we have our own business advice service, which I'll go into now. So the new business support service and the Tasmanian Business Advice Service is a free and confidential business advice service that we run through Business Tasmania. And through the new business support service, businesses or intenders who've had an ABN for up to 12 months or are yet to register their ABN can access up to 2 hours of free support each financial year. If you've had your ABN for over 12 months and have been in business for a while, then you can access up to 5 hours of free support each financial year. And as we are coming up to the 30th of June, those hours are going to reset on the 1st of July. So if you haven't already used up your 5 or 2 hours this year, I highly encourage you to get in contact with us and we can connect you with a business advisor. So the advisors we have are generalist business advisors, but they do have their own experience in various areas of business. So I encourage you to have a look online on the website. You can see the bios of each advisor with a bit of an overview of what areas they may specialise in. So you can see someone face-to-face who's in your area, or you can join a call online with a specific advisor if you have a request. And James, who is on the call with us today, he is one of our advisors for the Hobart region. So to access the service, you can go online to the Business Advice website and fill out the form, and the Business Tasmania team will connect you with an advisor, or you can call us on 1800 440 026 and get connected that way. As I mentioned, we host a number of events throughout the year. Here's the link to our event calendar, so eventcalendar.business.tas.gov.au. You can visit that page and search for events that are upcoming. In this series, our Cost of Doing Business series in collaboration with the TCCI, we have 2 remaining after this event, so next Tuesday and the following Tuesday as well. I highly encourage you to check out those events and sign up if they are relevant to you. All right, so just wrapping up the Business Tasmania section. So like I said, we are available 9 till 5, Monday to Friday, to help you with any business-related inquiry. You can call us on 1-800-440-026, or you can also email us. We are quite responsive on emails, so feel free to email us any business-related question, and we'll do our best to connect you with the right services. And if you're not already on our newsletter, I think it's well worth signing up to. It's the best place for you to find out news and updates on the business world in Tasmania. So things like any new funding programs, events, and any updates, for example, like legislative updates, we announce those or update you via our newsletter. So I highly encourage you to sign up to that one. All right, and then I'll hand over to Mikala and James to jump into today's topic on leasing a premises.
Awesome, thanks Bronwyn. Can you guys see the screen okay?
Yes, we can.
Wonderful, thank you. Thank you for the introduction. So James and I are going to be running through some information that you need to know about leasing a premises. I'll be asking the questions, James will be answering them, and then at the end, we encourage you to put any questions that you do have in the chat box, and hopefully we'll be able to get through them for you, because this is a very big and very interesting topic. So let's move on to question 1. What are the different types of leases and why does it matter?
Thanks, Mikala, and thanks, Bronwyn. Just as a start, leasing is a very complicated area, and there are a lot of hidden traps in there. So whilst we'll go through a lot of it, I'm really happy to take questions after, or if you have follow-up questions, I'm more than happy for you to contact me outside of the session to sort of work through any specific issues that you might have. So it's a really important starting place to look at that there are different leases that have very different rules and very different regulations that apply to them. The leases that apply to businesses with retail leases and commercial leases are very, very different, with very different rules than what you'd have for residential leases. So people can at times get confused that they think what's applied to them in a residential situation is then similar to what applies in a commercial or a retail lease. So as a starting point, there's 2 key differences between a retail lease and a commercial lease. So a retail lease is governed under the Fair Trading Code, and it applies to shops, cafes, salons, gyms, basically businesses that are actually selling goods or services, as opposed to a commercial lease, which applies to all other types of leases, and that includes office leases. So if you're just leasing an office, generally the retail lease rules and regulations will not apply to you. So with a retail lease, there are certain rules and regulations under the Fair Trading Code that provide statutory protections that cannot be contracted out of. And so they must apply regardless. And it can apply to things such as guarantees, it can apply to bonds, it can apply to a whole host of things that sets minimum requirements. However, some retail leases won't fall within that. If, for instance, it's more than 1,000 square metres, you're no longer regarded as a retail lease with all those protections applying to you. But regardless of which type of lease, whether it's a retail one or a commercial one, there are other protections that exist. For instance, consumer law applies things around misleading statements, unconscionable conduct, and a whole host of other issues that then also underpin both a retail lease and a commercial lease. So basically, commercial and non-retail leases apply to offices, warehouses, factories, anything that's not a retail lease. And the biggest difference is that when you have a commercial lease, you don't have the protections that a retail lease gets under the Fair Trading Code. So what that really means is that it's much more of a negotiation to put in place your own protections and your own security, because you're not supported by the minimum requirements under the Fair Trading Code. And this is an area that can get people very confused around what they can do and can't do in a lease. So it's really important to actually understand which lease is going to apply to you, whether it is a commercial one or whether it is a retail one. But consumer law likewise applies to the commercial ones. So you can't still do anything, can't have false, misleading conduct statements and the like. So that applies equally across both types of leases. So the key differences are built in for retail leases, protections negotiated for commercial. Security deposits are capped under retail leases. You can't require more than 3 months worth, where for commercial leases, you can require 6 months worth, 12 months worth. It is very much a negotiated position, and you can't contract out of the minimum requirements for a retail lease. Another key difference is when it comes to disputes. So typically in a retail lease, you'll have the ability to go to mediation through CBOS. That is not binding, but it is still a mediation process that you can go through with a retail lease, where as opposed to a commercial lease, you're really going through common law, through the courts or through the tribunal system where there is a dispute. So they're sort of the key differences between sort of commercial and retail leases from a overall sort of governance and structuring perspective.
James, can I just ask one question before we move on to the next question? It was what you said about the larger premises may fall outside the code. So does that mean that the larger premises will still fall under the retail lease, but just outside of the code? Is that what you were saying there?
No, so they'll fall outside of the protections that are provided under the Fair Trading Code. So under the Fair Trading Code, there's a code of practice for retail tenancies that does provide these minimum requirements. And for larger retailers, bigger than 1,000 square metres, they don't get that protection to be able to rely under the retail tenancies section.
Got you. Awesome. Thank you. All right. Next question. What are some of the standard clauses and why do they matter?
So this is just some of the more common ones. So there are a whole range of standard clauses that come into play, and they have very, very significant implications depending on the wording. So you really do need to read the leases very carefully. Even though it might be a standard form lease, there's often changes or adjustments made to it that can have some really significant impacts, particularly on the tenant. So, obvious ones, obviously the term and options. The term will cover off the start date, the end date, and option periods to renew. So when you have an option period to renew, it actually allows, at the tenant's option, the ability to be able to extend the lease for further terms over and above what the initial lease allows for. If there is no option to renew, what that means is the landlord can effectively, at the end of the lease, not renew you, kick you out, make you make you move, basically. So options, invariably what you want is as many options as you can get to give yourself enough surety that if you are in the premises, if they are working for you, if you don't want to leave, that you can extend out and not have to rely on the landlord's goodwill or landlord's willingness to let you stay. Rent and rent reviews will apply in all leases, and that can cover anything from how rent increases each year. Now, is it going to be a CPI increase, or is it going to be a set percentage increase, or is it going to be a review to market? So typically leases will have in them a review to market at some point. That's often at the point the lease is to be renewed. So there might be an initial term of 3 years or 5 years. Typically, it would have set increases at CPI or a set percentage up to the renewal date. And then when the renewal date is there, you would have a review to market where the landlord would typically try and set a market rent. You'll either agree or disagree. And then typically, if you don't agree, there'd be a process upon which you'd get an independent valuer to come in to actually assess what the market rent is, and that rent could typically be binding depending on the lease. Outgoings, you can have what's called a net lease or a gross lease, and this is where the landlord passes on additional costs to the tenant over and above what the rent payments are. So the outgoings could include land tax, they could include council rates, it could include shared property costs, it could also in certain circumstances include electricity or power costs or water costs. So outgoings can really be a hidden cost that a lot of people don't fully understand, or when they sign up to a lease, it will say outgoings are on top, but they can be, particularly when land tax comes into play, a very, very significant additional cost that isn't factored in to the actual cost of renting that building. Permitted use is another one which is a very standard clause, and what the permitted use clause effectively does is in the lease, it will tell you what you can use the lease for, the premises for. So sometimes it can be very specific. It can be as specific as saying you must have a Chinese restaurant and you must have a menu that's been agreed by the landlord. Or in which case you're limited to whatever that permitted use has been defined as. Or in other cases, it can be very wide. It can be your permitted use is anything retail, or it could be anything clothing related. So permitted use it is very much determines what you can and can't do within the lease. And if you wanted to change that, you would need to get the landlord's permission to agree to that change in use. GST will be a clause in pretty much every lease, and the GST clause will basically say, is GST on top or included in the rent that's been paid? Typically, most leases will say it's on top, but that's not always the case. But it's certainly, you need to consider that when you're actually signing up to a lease, because that potentially changes it by, well, effectively 10% on what you've got to pay, comparing an inclusive to an exclusive lease. Repairs and make good clauses can be a very, very costly one. So typically the infrastructure and outside costs of a building are the responsibility of the landlord, and the infrastructure costs, but the actual ongoing maintenance, which could be the carpet, could be the painting, could be the plumbing, could be the electrical works, are often to the expense of the tenant. And you can be caught out where a tenant signs up to maintain, say, the plumbing, and something goes drastically wrong. The tenant can potentially be responsible for the make good on the repair of that plumbing, even though that it mightn't be their fault. So really, really careful on the repair costs. And make good costs apply typically on the termination of a lease. So at the end of a lease, it's very standard that the tenant would actually have to pay for the building to be what's effectively called made good. So that can include it might be a coat of paint to make good at that point in time, or it can be to return the premises to what's called a base or reinstatement level, such that the tenant is responsible to strip out the building, to take out, might be shelving, might be walls, new walls went in, it might be the carpet, to take it down to a bare shell. And this very much changes from lease to lease, but the make good costs down to a bare shell can be very, very expensive, surprisingly expensive for what you would not think would be a whole lot to just clear things out. Security and guarantees invariably will be in all leases. That's whether there's a bond required, whether you need to provide a bank guarantee, whether you provide security payments by way of rent in advance. There is no, well, typically there will be a guarantee required or a security. It's very rare there won't be, but it's what is actually required. And in the case of a retail lease, that's limited to 3 months. It can't be longer than 3 months. But that doesn't mean that if you've signed up to guarantee a lease, that you're not responsible for payments throughout the whole term of that lease. So in a 5-year lease, if you got out of it after 1 year and you had a personal guarantee, you are still responsible for the lease payments for that full period of time. And this is something that can be a real nasty bite. You know, if you've got a business that hasn't worked out how you wanted it to work out, to then be caught with ongoing leasing and rental payments for a period after the business has stopped. Assignment and subletting. This is your ability for you to actually sublet or lease out part of the premises to another business, or to actually assign the lease. So you can actually assign across your lease to, it might be someone buying your business, or it might be you're closing the business, or it might be you're just moving your premises. So this is your ability to actually assign it across to someone else, and there will be conditions in the lease that outline what has to be done. Typically, you do it such that provided that the person or you're assigning to was had financial standing or the financial capacity, that the landlord could not withhold their consent to allow you to assign it unreasonably. But you just need to be careful with the words, and you just need to make sure that that's properly reflected, as it is very much a standard clause in pretty much all leases. Insurance is another potentially very costly one. So for retail leases, it's very standard to have public liability insurance, to have plate glass insurance, and plate glass can be a very expensive insurance to get, because the large windows in retail settings are very, very expensive to buy and to install. So it's very common that a landlord would require the business to actually have a specific plate glass insurance to cover it. But insurance cover that we're seeing more and more coming up is landlords trying to get the tenant and make the tenant responsible for the actual building insurance. So what they're really doing is pushing their cost onto the tenant to actually cover the insurance for a building, construction, demolition, whatever, fixing the building up, which typically you'd regard as being really a landlord cost, but then more and more we're seeing landlords trying to push it to have the tenant pick up that cost. And that can be a very, very expensive policy to have as well. Fit out obligations, very common. Who pays for what? What approvals are required? What reinstatements required? How often does fit out have to occur? Leases often have obligations in there for the tenant to have to do a repaint or refresh or fit out at certain periods of time. That's very common, especially in shopping centres, where pretty much applies in all shopping centre leases, which have different rules again. But again, those obligations can be a hefty cost that aren't often factored in. If you actually have to, say, every 5 years do a complete fit out or complete repaint or remodelling, you need to really take into account when you're looking at the total cost of what leasing those premises are. And then there'll be default and dispute clauses, typically whether you go through mediation, you go through the courts, whether you go through CBOS, they would all be spelled out in a sort of a standard or typical lease arrangement. Any thoughts on any of that?
James, we do have one question. When you mentioned rent review, someone has asked what would be the best option from the three that you mentioned? Because I think you mentioned CPI percentage and market increases.
That's a really tough one to answer because it's a very subjective. A typical fixed percentage historically has either been 3 or sometimes 4%. So that is a percent that applies on each anniversary. The rent would automatically go up by that amount. I have seen a number of leases where they've gone for 5 and 6% the landlords wanted, which when you look at 1 year doesn't sound like a whole lot, but when you actually take that over, say, a 5-year lease, that effectively means your rent will have gone up 30% over a 5-year period. So it can really mount up. So the opposite, well, not the opposite, the alternative to that is usually a CPI one. And so you're betting on whether CPI is going to be lower or higher than what that set percentage is. So I think, historically, CPI has often been a better result than a set amount, but it very much depends on what that set annual adjustment is. Then a market reviews a different mechanism again, in that it doesn't look at an annual percentage. Market reviews typically only happen at the end of the lease period, where there will be a mandatory market review, and that's to protect both the landlord as well as the tenant. Because depending on the leasing conditions and the property market, leases can go up or potentially can go down. So the review to market is actually an area that we often see has quite a considerable level of conflict arise, shall we say, because it's the landlord wanting to get the rent up as high as possible, and the tenant obviously wants to keep it as cost effective as possible. So the review to market normally doesn't happen on a yearly basis or 2 yearly basis. It normally happens at set periods of time, and that is typically at the end of a leasing period.
Great, thank you for that. All right, let's move on to question 3. What are some of the risks to watch out for?
Yeah, this is these are probably the most typical risks that we actually see coming up on a regular basis. And that as a starting point to work out which rules apply, and that is it a commercial lease or is it a retail lease where you can rely on the minimum conditions? Personal and directors' guarantees. This is absolutely a key that people can sometimes understate and underestimate, because it really does. If you've provided a guarantee, you're personally liable throughout the term of the lease for lease payments. Yes, the building might be released and you can be released from your guarantee, but you're wearing the risk that you're guaranteeing the payment, and this can obviously have some pretty nasty consequences. Outgoings and land tax can be a very hefty payment too. A lot of leases will not stipulate or will not spell that out. So you'll find that people sign up to a lease, it will say plus outgoings, which could be defined to include land tax, and then have a very, very hefty land tax bill that can be a significant portion on top of what the lease payments are. So understanding up front before you sign the lease what all the outgoings are and how much they are, and even looking at ways that you can put a cap on it. So negotiating to have a cap on the amount of outgoings or land tax you can be forced to pay is certainly worth considering. Building insurance, as I mentioned, I've seen more and more landlords trying to pass that responsibility onto the tenant to have them pay for the building insurance, which historically has been a landlord cost, but it is a hefty cost, and often seeing it as one of the clauses that you need to negotiate pretty heavily on. Make good obligations, we've touched on as well. This is your need to actually make good the building at the end of the lease, and this can be anything from stripping it out, taking it back to bare bones, or it can be painting, new carpet, a whole host of things. Typically, though, a lease will allow for fair wear and tear. So if you would have a clause in there that might say you have got to paint it, or it might say you just need to maintain the premises subject to fair wear and tear, in which case you may not need to. But it's really important to understand the financial implications of all these things, because they can have a very, very significant financial impact, and they are often not understood or not really factored into the total cost of leasing. Then option exercise deadlines. If there is an option, typically it will have a date upon which the option needs to be exercised by. If you miss that date, the landlord then does not need to renew the lease if they don't want to. Typical exercise periods are either 3 or 6 months from the end of the lease. You will have, as tenant, have to provide the landlord with a notice saying that you wish to exercise your option, or if you don't, the landlord can remove you at the end of the period. That said, they can't make you stay on if the lease is up and you haven't exercised an option. But diarising those dates is really key, because you miss the date and you miss your ability to be able to extend the lease potentially. Just some other things to sort of watch out for, though. That's sort of the real high risk ones. But planning approval and zoning. A lease will typically put the responsibility for you to make sure that your business fits within whatever the approval and zoning requirements are. So you need to ensure that your intended use of the premises is consistent with that zone. And that also fits into an existing use rights. So the zoning of premises might change over time, but if you're already in there operating a particular type of business, you might have an existing rights use. But if you sold the business or if someone new came in, that doesn't automatically allow the new person or the new owner or the new business to be able to operate the same way you did, because that's, if the zoning's changed, you may be subject to the new zoning rules that doesn't transfer across on change. You've got the building compliance to make sure that the building is compliant, that when you look at it, that there's the proper fire, health and safety, sprinkler, disability, all those accessibility issues, that you're not going to be picking up an expense to be responsible for them. So before entering into a lease, you need to really understand, are there any compliance issues that I need to be aware of? And are there any accessibility issues that I need to be aware of, such that you're not going to be responsible for making good either the fire issue or the accessibility or the disability access issue after you enter into the lease, because they can very often be the responsibility of the tenant, not the responsibility of the landlord. So understanding those is key up front. Parking rights, particularly in areas where there's shared car parks, doesn't automatically apply that you will be allowed to use parking, even if it is located at the building, particularly where it's a shared building. So you need to make sure that parking rights are spelled out in the lease in terms of what you do or don't get, what your customers can get, and just whether additional payments are required. Signage, very standard clause is that the landlord needs to approve any signage that appears on the outside. You've also got council you need to watch out for there, because they also have their own requirements around what signage is or isn't allowed. Exclusivity rights is an interesting one. Exclusivity rights is where it might be in a shopping centre, it might be in a strip shop, where a landlord might have multiple shops or multiple sites, where if you're a takeaway shop, you mightn't want another takeaway shop opening up next to you. So what you actually have written into the lease is exclusivity rights to say that you're the only shop or outlet of a particular type that is allowed in that, might be shopping centre, it might be that strip that is under that landlord's control. So it stops them opening up a competitor right next door to you. And this is something which I've come across a number of times now, where particularly in shopping centres, where the centre management will put two competing shops right next door to each other, that has a really significant impact on the viability of it's always been the one that's been there the longest, because they weren't aware that a competition could be brought in directly against them. Condition reports is something that's really highly recommended. It's where, when you go into the premises, you actually have a report done, or if you don't have a report done, you actually film and you take photos of the premises, of the condition of it, such that if at the end of the lease there's a make good clause or there's a fair wear and tear clause, that you're able to actually demonstrate and say, no, this is fair wear and tear. No, this was the condition of the property when I moved in. so you're not forced into a situation where you're having to make good or fix up issues that were already in place when you took out the lease. So the condition report, or at least photographic evidence, is highly recommended when you start to lease new premises. Registration requirements. So typically leases over 3 years for a retail lease. It's different for commercial lease. You should get registered. You don't have to. It's not a legal requirement, but it just protects your rights in the case that a landlord sells the building. If you've actually had it registered, it can stop the new owner from making further changes to the lease. Rent review terms, we've already discussed that. CPI set amount or review to market. And building maintenance and compliance is another issue that you need to really carefully look out for, where landlords can often try and push onto the tenant the need to comply with things such as fire safety, servicing, checks, and various things where historically they have been landlord costs, but more and more we're seeing landlords trying to push these compliance costs, particularly around things such as fire safety, onto the tenant to comply with. So they're just a number of issues. It is a very detailed list, but you really need to read through the lease carefully and really understand just what all these mean, and more importantly, what the potential implications can be. It's really easy to sort of read through them and think, yeah, that looks okay, but to understand the financial implications for some of these can be very significant.
Thanks, James. We do have a question, but I'm actually going to get the person to come on at the end live to ask you that. So we'll move on to the next one. What should businesses do if things go wrong?
Unfortunately, things do go wrong, and too often go wrong. The three which I'd probably see the most of is rent disputes, particularly over rent increases, repairs, either not being done where the landlord won't repair something, or alternatively where the landlord wants the tenant to and they don't want to. And outgoings is another one where hidden outgoings come up, particularly around the land tax and council rates that aren't properly understood. The list is much longer than that, but they're three very typical ones that we see all too often. So the thing you really need to do, and it's pretty obvious, is you really need to read the lease really carefully and really understand the terms and conditions, and have someone explain what the financial impacts are. Because the financial impacts, and I keep coming back to it, is probably the major issue that we have coming through with people being hit with costs that they don't think are fair or reasonable. So understanding those costs is critical up front. But then in the leases, there will always be a dispute resolution clause. As I mentioned, under the Fair Trading Code, there will be the ability to go through CBOS. That is not a binding process, but it does provide a mediation route. It might provide for an independent mediator to be nominated, sometimes appointed by the Law Institute of Tasmania is a very common way that they'll appoint a mediator. Or you might be through the court system, through the tribunal or potentially magistrates court system. So making sure that you read through the lease and understand what the right process is, and you don't miss out on the steps that have been laid out in the lease. I'd always recommend to just raise it in writing. It's not a he said, she said. making sure it's fully documented and written so there can be no ambiguity and dispute over what the issue is. And if you can resolve directly, it's a much, much better way to go than getting the lawyers involved and paying for legal fees. That said, if it does look like it's going to be nasty and going legal, I'd be absolutely getting the legal assistance as soon as you believe it's necessary. But if you can resolve it directly without going through that route, you're much better off financially by doing that. You then, as I mentioned, you got CBOS for retail leases, get the legal advice, and then only as a last resort would you consider going the tribunal or court action route, just because of the costs that can add up so quickly. Things just to be aware of, though, is that whilst you might be in dispute, if you miss things like extending the lease out under the option period, even if you're in dispute, if you don't exercise those notice periods and they lapse, you lose that right to be able to extend. You lose those rights that the option provided you with. And likewise, stop paying rent. You need to be very careful of stop paying rent, even if you're in dispute. And you'd definitely be wanting to get legal advice before you stop paying rent, because that can make various other terms and conditions null and void, or it could even mean that the lease can be terminated on you and you can be removed. Retail leases and commercial leases here are very, very different than what a residential lease is. And this is an area where some people get very confused in terms of what their rights they can and can't do, because the rules around this are totally different. Any thoughts there?
We might move on to the next question because I'm just being mindful of time. What are the typical steps to go through when leasing a premises?
So this is a pretty sort of typical sort of process. You know, you find the premises, you get the right size, building location, all the rest of it. You then want to check the planning approvals. So that'd be the first thing you do, is to make sure that the type of business that you're wanting to set up and the planning approvals are all suitable for it. From there, you'd move through to what's called a heads of agreement or a letter of intent. And what that typically is a very short document. It might be 2 or 3 pages that just spells out some of the key terms, like how much the rent is, what option periods are attached, when rent reviews will occur. Not all leases go through a heads of terms or letter of intent. It is often done, though, just to save time and effort by making sure both parties are in agreement on what the key terms are before going into a really detailed 30, 40-page lease agreement or more. The letter of intent or the heads of agreement is usually not binding, although sometimes they are, and sometimes some of the clauses are, such as confidentiality. But if you're signing a letter of intent that is fully binding, you need to be very careful, because further clauses can then slip in or come in as part of the detailed lease agreement that weren't fully outlined in the letter of intent, that you might then be obligated to adhere to, even though you didn't fully understand or weren't advised of all those terms up front. Confirming which rules, the commercial versus retail. You then get the lease drafted and you do your due diligence working through it. Typically, a lease will require some type of guarantee, and that's often a bank guarantee. And we have come across it a number of times where people have signed up, but then weren't able to actually get the bank guarantee in place. The banks wouldn't provide it to them. So they've then had to actually go down the route of getting other guarantees or financial surety in place that can be quite costly, or might even put strain on their finances if they've actually got to come up with the cash by way of a cash deposit guarantee where a bank guarantee hasn't been available. Have a lawyer review and negotiate. So unless you're very familiar with leases and lease terms, it is definitely best to have a lawyer go through it for you. Once you've done that, you pay the security and the guarantee, sign the lease. And then what's really important too is just diarising those option dates. If you miss an option date, because that might be 4.5 years' time on a 5-year lease, if you miss the date, you might list the ability to be able to extend the lease. So a typical process, but it does certainly change depending on the circumstances.
And what are the typical costs to get legal assistance and review?
So there's no law enforcing a legal review. Often, though, in the case of a retail lease, if the lease is for less than 5 years, there's an automatic protection under retail leases that a 5 years is provided. So often landlords will require as a condition that there is legal sign-off. And you'll often need a legal review if you want to get the lease or the deed registered. So typical sort of costs a simple review, $750 to $1,000, a full commercial review. I've got down here 1,000 to 3,500. We certainly see them go much higher than that in certain circumstances. And if the lawyer is going to do the negotiation, it's whatever their hourly rate is. A junior probably $250 an hour or so, up to $700-800 an hour for an experienced lawyer to negotiate it. A guarantor advice is often something that the landlords insist you get, where that is just a lawyer explaining what your obligations are as a guarantor. It's called an ILA as well, which is an independent legal advice. And that's sort of somewhere around that $450, $500 is a pretty standard sort of fee. Then you'll have your GST and disbursements on top. So the price varies quite a lot depending on how much effort's involved. But typically you're going to be looking at $750 as a bare minimum for quite a simple review to several $1,000s.
Thanks, James. And what are your key takeaways from everything that you've spoken about today?
Yeah, key is before signing the lease, just making sure that you can use the premises for what you want to use it for, making sure that you understand the category, being the retail or commercial, so you know what protections you do or don't get. Reviewing all terms and conditions to really understand the financial implications, obligations, and risks that what sits with you and what sits with the landlord. Making sure you understand the full occupancy costs, which includes all the add-ons, particular land tax, in particular council rates, and particular just those make good costs at the end, which need to be factored in if you've actually got to change or make good the premises to a certain standard or level. Diarising all dates, and absolutely, if you're uncertain about anything, getting the legal advice, because it is a very complicated area with a lot of pitfalls that aren't always evident on reading. So that'd be sort of the key takeaways in terms of the real high level issues that you really need to consider.
Fantastic. Thanks so much, James. What we might do now, I might hand back over to Bronwyn just to wrap us up, and then anyone who has any questions can stay on and we'll deal with those after the recording ends.
Thank you, Mikala, and thank you, James. James, I've got one final question for you, and that is, if someone was to access the Tasmanian Business Advice Service or New Business Support Service for some support before they, do the deal on leasing a premises, how could you, as an advisor, help them through that process?
Now that's actually a good question, Roman, because that comes up all the time. As I'm not a lawyer, I can't provide legal advice. But we do review an awful lot of leases. So what we can actually do is do a commercial review and can work through the various terms, the conditions, the things we spoke about today, and can certainly explain what the implications are and what it means to give you a better understanding, albeit you might then make a decision at the end of the day that you do need to get legal review. Particularly if that is a condition under the lease that they actually require it. So working through the lease, working through the process and helping explain terms, conditions, clauses and what the implications are.
Yeah, fantastic. So it's a good place to go during that process to have some extra support. So that's fantastic. So just as I mentioned before, if you're interested in getting support through an advisor, you can head to the businessadvice.tas.gov.au website and sign up. And if you're interested in getting any support for employing staff, you can contact us at Business Tas or go to the Tasmanian Chamber of Commerce and Industry with Mikala and her team to also get a free advisor for support with employing people. Thank you for joining us today, everyone, and we hope to see you at the next one.